What makes this enforcement action even more destabilizing is how quickly it shatters one of the most persistent myths surrounding power in America. For decades, Trump cultivated the image that his wealth and status placed him beyond ordinary consequences. That narrative was not just political, it was central to his brand. Judges, regulators, lenders, and even critics were portrayed as obstacles that could be outmaneuvered, delayed, or worn down. This seizure order directly contradicts that mythology. It demonstrates that when legal processes are allowed to run their full course, status does not function as armor, time does not erase obligations, and refusal does not equal immunity. Inside the New York legal community, reactions were blunt. Veteran attorneys described the order as inevitable rather than shocking. From their perspective, this is exactly how civil enforcement works when a judgment debtor refuses to engage in good faith. Courts do not negotiate indefinitely, they escalate. And once escalation reaches the asset seizure phase, judges rarely reverse course without full compliance. This is why so many legal analysts emphasize that Trump's mistake was not losing the fraud case alone. He was assuming the defiance would stall enforcement forever. That assumption proved catastrophically wrong. The mechanics of what happens next are methodical and unforgiving. Court-appointed officials oversee valuation. Noted assessors sent to creditors and lien holders, appraisers, assess market conditions under forced-tail constraints. The properties are prepared for auction or private liquidation under court supervision. None of this happens overnight, but once it begins, it rarely stops. Each step reduces the original owner's leverage. Each delay increases costs and interest, and each public milestone reinforces the perception that the process is moving forward regardless of protests or political pressure. What makes Trump Tower uniquely significant is not just its monetary value, it is its symbolic role. For nearly 40 years, Trump Tower has functioned as a visual shorthand for Trump himself. Campaign announcements, media appearances, gold-lettered branding. Losing control of that space is not comparable to selling a golf course or an office building. Quietly, it is a public dismantling of an identity centerpiece. That is why images of state officials entering the building resonated so strongly. They conveyed something words could not. Control had changed hands. This moment also exposes a deeper contradiction in Trump's legal strategy. On one hand, he presents himself as immensely wealthy, a billionaire many times over, capable of funding campaigns, businesses, and legal fights with ease. On the other hand, he claims that posting a bond required of countless defendants is impossible. Courts are not persuaded by rhetorical wealth. They rely on documented capacity, and when a defendant's own financial disclosures show ample assets, claims of inability collapse under scrutiny. That inconsistency is precisely what Judge Engoron highlighted. It transformed the narrative from hardship to defiance. Their political consequences are already rippling outward. Within Republican circles, the response is fractured. Some leaders echo Trump's claims of persecution, framing the seizure as an attack on conservative voters by liberal institutions. Others are noticeably silent. Silence, in politics, is rarely accidental. It reflects discomfort, uncertainty, and concern about association. When donors, strategists, and elected officials see a figure losing assets due to non-compliance rather than persecution, enthusiasm cools. Money follows predictability. Chaos repels it. At the same time, Democratic operatives view the situation through a different lens. For them, this is not merely a legal victory, it is a validation of institutional resilience. Courts functioned, deadlines mattered, enforcement followed. That narrative reinforces faith in the system among voters who worry that powerful figures operate under different rules. Whether that perception holds will depend on what happens next. Enforcement without follow-through would undermine credibility. Enforcement carried through to liquidation would cement it. Beyond politics, the case is already being studied in law schools and judicial conferences. Professors point to it as a rare example of civil procedure operating under intense public scrutiny. Students analyze the timeline. Extensions granted, opportunities offered, deadlines missed, enforcement triggered. The lesson is straightforward. Due process does not mean infinite patience. It means fair opportunity followed by consequence. Trump's public response, however, continues to avoid that core reality. Attacking judges and prosecutors may energize supporters, but it does nothing to stop liquidation clocks. Courts do not respond to social media pressure. They respond to filings, bonds, and compliance. That mismatch between rhetoric and remedy is why legal analysts describe Trump's position as increasingly untenable. Every day spent escalating political outrage is a day not spent resolving the underlying enforcement issue. The risk now is compounding damage. Forced sales rarely achieve optimal value. Buyers know the seller lacks leverage. Discounts widen. Assets that took decades to assemble can be dismantled in months at a fraction of their perceived worth. That reality is especially painful for someone whose brand depends on perceived dominance and control. Once properties are sold under court supervision, there is no mechanism to reclaim them even if later appeals succeed. The damage becomes permanent. This also alters Trump's future legal posture. Judges across jurisdictions observe behavior. A defendant who ignores one court order invites skepticism elsewhere. Compliance history matters. When future judges assess motions for stays, extensions, or accommodations, this record will be part of the background. Defiance carries long memory. In legal systems, supporters argue that appellate intervention could still halt everything. That remains theoretically possible, but increasingly unlikely without substantial compliance. Appellate courts are reluctant to reward non-compliance. Stays are discretionary, not automatic, and discretionary relief depends on good faith. 11 months of refusal erodes that argument severely. Meanwhile, practical consequences continue unfolding. Tenants seek clarity about leases. Insurers reassess risk. Contractors pause projects. Every business relationship connected to seized properties enters a holding pattern. Uncertainty spreads outward, affecting people far removed from the courtroom. Drama. This is another reason courts emphasize timely compliance. Delays do not occur in a vacuum. They impose costs on third parties. As this unfolds, one constitutional principle remains central. Equal justice under law is not measured by rhetoric. It is measured by outcomes. When courts apply the same enforcement tools to powerful defendants that they apply to ordinary ones, legitimacy strengthens. When they hesitate, legitimacy erodes. This case sits precisely at that crossroads. The judiciary's credibility is on the line alongside Trump's assets. There is also an international dimension, often overlooked. Global investors watch how legal systems treat powerful figures. Predictable enforcement attracts capital. Arbitrary enforcement repels it. The United States has long marketed itself as a nation of laws, not personalities. This case tests that claim under extreme conditions. The outcome will be cited in boardrooms and risk assessments far beyond New York. As days turn into weeks, attention will shift from shock to process. Auctions, filings, appeals, each step less dramatic than the last, but collectively decisive. This is how accountability usually looks. Not explosive endings, but incremental, procedural closure. Trump may yet choose a different path. Posting bond, negotiating payment, or settling could still halt liquidation. Courts are not interested in spectacle. They are interested in resolution. Compliance, even late-night, can stop further damage. The question is whether Trump is willing to accept that compliance does not equal surrender. It equals participation in a system he has long claimed to respect, even while challenging it. For now, the situation stands as follows. A civil fraud judgment stands. Enforcement authority has been granted. Property control has shifted. Liquidation pathways are active. Appeals remain uncertain. Political narratives rage, but legal machinery continues moving forward, indifferent to noise. This is why the moment matters, not because it involves a famous name, but because it demonstrates something foundational. Courts are not symbolic institutions. They are operational ones. They issue orders, they enforce them, and when defendants choose defiance over compliance, the consequences arrive not as hypotheticals but as court officers at the door. The next phase will determine how far this goes. Either compliance intervenes, or liquidation proceeds. Either way, a line has already been crossed. The idea that a former president could indefinitely ignore a civil judgment without consequence has been tested and found wanting. That is the real significance here. Not partisan victory, not personal downfall, but institutional proof. Proof that court orders mean something. Proof that deadlines matter. Proof that accountability, however delayed, still functions. And once that proof is established, it reshapes expectations for everyone who follows.